when you look at what is going on in the area of journalism and civics together, the folks in this room and the folks at McCormick Foundation just get it in such a deep way that I wish more folks on the sort of philanthropic side would really understand that, we tend to think about civic education as something that you do in a social studies class, but you all know from participating in journalism that civic education is not something that you get delivered to you out of a textbook that involves guys in powdered wigs and parchment, right? I mean, it involves rolling up your sleeves and getting dirty and getting out into the community and seeing what school boards and county commissions and courts are all about, and that is civic education, but it's civic education that makes a difference and that's memorable and where you're actually making an impact while you're doing it. So I'm just so delighted that the people at McCormick get that just deeply in their DNA, and I wish we could put these guys through a copier or something and have 100 more like them. But so I really am so grateful for this invitation and for their support. This is a very exciting day at the Student Press Law Center because I'm on an airplane for like 3 hours today, and so my phone is off, right? And when I switch it on at the end of the flight, bing, 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 bing. All of a sudden, these things start going off, and that's usually bad news, right? It's usually like some horrible thing is happening to your family, and you're thinking, oh my God, it's horrible. I'm gonna have to get back on the plane, turn around. What all of these messages said was some variation of this: boobies. This was the message, and as I started reading them, as I started reading them, because obviously that intrigues you can't not open that message, right? I mean, come on. Yes, the Supreme Court just this morning announced that they will not take a case that involves the First Amendment rights of students. And sometimes the fact that nothing happens is a cause for celebration, right? I mean, being shot at and missed is cause for celebration, right? And we were shot at and missed this morning. Some of you probably followed this in the news, and it will be on the news tonight. It's a big deal. Last year, a federal court of appeals in Philadelphia, right? And you guys who follow legal news, right? You bring a lawsuit in a district court. From there, it goes to a court of appeals. From there, maybe it goes to the Supreme Court, but usually not. The Supreme Court has discretion of what they take. They take almost nothing, okay? This was a case that got decided by a federal appeals court in Philadelphia last year. And it will amaze and astound you to think that people with Harvard law degrees sit around in their robes debating things like this, but I promise you they do. I worked at one of these federal courts of appeal, and it's remarkable. They were arguing about nothing less than whether the message on an awareness bracelet was or was not protected speech when worn by a student inside of a K through 12 school during the school day, and what the bracelet said was, I heart boobies. Right? This was a cancer awareness bracelet that two middle school students in the Philadelphia area were punished for wearing. These students both had experience in their extended family with breast cancer, and so it was a very heartfelt thing for them that they wanted to call attention to breast cancer. They got these bracelets from a legitimate charity called the Keep a Breast Foundation, right? And the Keep a Breast Foundation, this is their little tagline to get people to pay attention because, cancer is sort of a bummer, right? And we're trying to get people to pay attention and go visit the website, and this was their idea, was, hey, let's have this catchy slogan, I heart boobies, keep abreast, with their website, and, it's worked. People visit the site, and it's stimulated discussion. Well, in the mind of the school district, this was going to stimulate the wrong kind of discussion, and so they decided that they were going to suspend anybody who showed up at school wearing one of these bracelets. The students actually got legal counsel and won the case. They won the case at the Third Circuit Court of Appeal, one notch below the Supreme Court. The school district was unhappy with the result. They asked the U.S. Supreme Court to take it, and this morning at 10 a.m., the Supreme Court announced they will not, meaning what? That the ruling below at the Third Circuit Court of Appeals stands. It holds up, and it is the law. It is the law, at least for that geographic area, right? Because these courts handle different geographic areas around the country. You're sitting in the Seventh Circuit right now. The Seventh Circuit isn't bound by that ruling, But this is the first one that we know of involving that very exact issue to get all the way up through the courts and conclude. And so it's possible that that ruling might be influential on other courts around the country. Now, why are we arguing about this, right? I mean, we're the Student Press Law Center. Why do we care about the right to say the word boobies in school during the school day, right? The answer is because courts never write with a surgical scalpel. They paint with a big, broad paintbrush, right? And so when they paint with the big, broad paintbrush and they tell us what the law is, it's not going to say, right? That ruling is not going to say students have a First Amendment protected right to wear boobies bracelets. It's going to say something much broader than that. It's going to say something like students have a right to discuss social issues of public concern, even if they use coarse language when they do it. Well, so now we're starting to talk, right? Because now this is starting to look like something that might benefit people who do journalism, right? Because after all, every once in a while, suppose you're writing about sex education. Suppose you're writing about sexual assault. Suppose you're writing about issues of public concern that necessarily require you to maybe use an anatomical term, right? At least as far as the Third Circuit Court of Appeals is concerned, that is now constitutionally protected speech that a school cannot lawfully infringe. Public school, anyway, right, cannot lawfully infringe. That's good. That's good news. It's not just good news for people with cancer bracelets. It's good news for everybody that wants to engage in discussion of political and social issues that they care about. We often find, and this is an example of this. Who knows who this is a picture of? That's okay. She's not known for her face. She's known for her name. She's known for the case that bears her name, Mary Beth Tinker of the Tinker versus Des Moines case, right? If you don't recognize that, we'll talk to you about that in a second. But we often find that the rights of journalists are really joined at the hip with the rights of other speakers. And the cases that go to court that benefit journalists are usually not about journalism at all. Usually journalism kind of rides in on the coattails of some other speaker, right? They're usually cases like this one. Back in 1965, Mary Beth and her brother John get kicked out of their high school in Des Moines, Iowa, because they want to wear a different kind of bracelet. They want to wear an anti-war armband, right? This was the I Heart Boobies of its day, I suppose. And they want to wear these anti-Vietnam War armbands in 1965. They're kicked out of school and told, don't come back until you take the armband off. If they get an attorney, they go all the way up to the U.S. Supreme Court. The Supreme Court did take this one, and in 1969 told us in the Tinker case that students have a constitutionally protected right in the public schools to do that, to engage in non-disruptive political speech. And that is the law of the land, and it still is the law of the land today. And, right, although there was no journalism in this case, although there were no journalists in this case, this is also the rule that protects the ability of people to do journalism touching on sensitive issues of social and political concern. Now, unfortunately, hi, come on in. Now, unfortunately, you missed the happy part of the story, and now I'm going to get to the bummer part of the story now. So, yeah, unfortunately, that's not where the Supreme Court stopped writing. If the history of the law of student speech had stopped in 1969, schools would be a much better place, but it did not. What happened is, in the 80s, the Supreme Court sort of took a turn toward the more authoritarian side, and in the 1980s, the Supreme Court decided a case called the Hazelwood case. Who has heard of or perhaps been on the receiving end of the Hazelwood case in their own school experience? Well, I'm glad to see not every hand went up. That makes me happy. Hazelwood is the one and only high school journalism case to ever get in front of the U.S. Supreme Court. And in 1988, what the Supreme Court told us was that Mary Beth Tinker's case is still the law of the land when you're speaking using the words coming out of your own mouth or worn on your own body. But if you're using a vehicle that the school pays for as part of the school curriculum, then different rules apply and lesser First Amendment protections apply. The line between where the school's authority begins and ends has been moved. The line has been moved so that the school can censor what students want to say or write as long as they have some sort of a reasonable educational basis, a reasonable educational justification, which, right, is much less protective than what they told us in the Tinker case. And so when you're using that school-funded newspaper, yearbook, theatrical performance, graduation speech, anything that it looks like it's part of the school's educational day, you're going to have very minimal First Amendment protection. That was the rule for high schools, and we thought it was only for K-12 schools until a federal appeals court here in Illinois came back in a case called the Hosty case a few years later and told us that it was also the rule for college students as well. That college students at a public university would have no greater First Amendment protection than an 8th grader or a 9th grader would have, and that as long as the school had some legitimate reason for the censorship, the school would win and the speaker would lose. But that's still not the end of the story, because it is possible for states to give more rights to people than the bare minimum the U.S. Constitution gives you, right? The Constitution's a floor. It's not a ceiling. The state or your county or your district or even your school can always give you more rights, right? They just can't give you fewer. And that's what the state of Illinois decided to do with something called the College Campus Press Act. And so those who are at a public college in the state of Illinois have the benefit of the College Campus Press Act, which says the Mary Beth Tinker rule applies. That as long as you are not doing something that disrupts the operation of the school, we're going to cause people to have fistfights in the hallways or walk out en masse, panic and not come to campus. As long as you're not doing any of those things, the speech is your own, and the school can't censor it or can't punish you afterward for saying it. So the job is half done in the state of Illinois. We got the College Campus Press Act passed, but what we didn't get passed was a comparable level of protection for people in K-12 schools like 7 other states have. That is why, and with this I'm going to wrap up and listen for a while, that's why my wristband doesn't say boobies, it says Cure Hazelwood. And I have one for everybody here in this room as well to make sure that you don't leave empty-handed. This is our campaign to cure the cancer that is Hazelwood, the cancer that eats away at civic education and journalism in our schools, because we know after 26 years of experience with this that Hazelwood doesn't work. And that's not just our word, that is the word of the Society of Professional Journalists, the Journalism Education Association, the Journalism Professors Association, everybody who is involved with the teaching of journalism, the learning of journalism, and the hiring of journalists has all said, we don't want people having to work under the Hazelwood standard because it is cancer to good journalism. It is too much governmental authority over the watchdog role. And you guys are watchdogs in your schools that students should be performing. It used to be, I actually was an education reporter for a little while before I went to law school. I was an education reporter down. I did an internship actually down in Fort Lauderdale, Florida. This is where I most remember covering schools. This is a really long time ago, guys, a really long time ago. And I remember that you used to be able to just get your spiral notepad and just show up at school. Just walk in the door as a journalist and say, "Hi, I'm here to talk to some kids," and they would say, "Go to it. Go for it. Help yourself. Stay as long as you want. Make yourself at home." Right? Those days are gone, okay? There's no metal detectors. There's no drug sniffing dogs. There's no nothing. It was just, help yourself. You're a member of the public. This is a public school. Go to it, right? That's not true today. That's not true today. I don't know how many of you have ever seen a professional journalist enter your school, but if you have, it was probably after a shooting, right? That's when they show up. They don't show up to cover what's going on in the classroom. They don't show up to write about education policy. They show up because there's a shooting or meningitis or a gang fight, right? That's when they show up. That's the only thing that makes the news anymore about schools. Who's going to replace that news that we don't get from the professionals anymore? The people in this room are. You have to. You have to. You're our only hope. You're the only way that we will know. You're our last line of defense for us to know if schools are dirty or dangerous or ineffective or overcrowded, because if you don't tell us, we'll never find out. That's a lot of responsibility, but it's a lot of power too. I mean, you are it. You are the public's eyes and ears. We depend on you and we need you. And that's why the Student Press Law Center, that's our website, splc.org. We're celebrating our 40th birthday this year. We're going to have a birthday party this fall. That's why Student Press Law Center was founded 40 years ago, was to be sort of, this counterweight when you feel like you're outgunned, And I know it. I've been there, believe me. I was the editorial page editor in my high school. I was in the principal's office every issue. Every issue I was in there, you know. Why'd you write this bad thing about student government, you know? And if only I had known, right, that these guys were a phone call away, but I didn't. But it's a counterweight. It's really meant to be an equalizer. That when you feel like you're outgunned, when you feel like the odds are against you, you have a friend. We are in Washington, D.C., but we're as close as a phone call or an email, and I'll make sure everybody gets a business card too. But take advantage of the service. That's what it's there for. And not only will we help you out with First Amendment and press freedom issues, we've got teaching resources on there, everything from copyright to open records to dealing with police officers, a big issue for photojournalists these days, and one where the law is actually improving, which we can talk about. But with that, let me just sort of hear what's on the minds of everybody in this room. I'm just thanks so much for making this time to share with me.
Great.